Why is a termination clause crucial for legal agreements? Have you ever wondered why a termination clause is so important in legal agreements? Let's break it down in simple terms. A termination clause is a key part of any contract. It clearly states the conditions under which the parties involved can end the agreement before it naturally expires. This clarity is essential for preventing disputes and misunderstandings down the line. When you include a termination clause, you set clear expectations about how and when a contract can be terminated. This acts as a safety net for both parties, protecting them from unexpected or unfair contract endings. Without this clause, you might find yourself in a tricky situation where you cannot exit the agreement without facing legal consequences. One common mistake in contract drafting is failing to include a well-defined termination clause. This can lead to confusion and disagreements. If there is no clear path to exit the agreement, you may end up breaching the contract or being forced to perform under unfavorable conditions. So, why is a termination clause so vital? First, it defines the grounds for ending the contract. This could include reasons like breach of contract, insolvency, mutual consent, or changes in control. By specifying these reasons, you avoid ambiguity and ensure everyone is on the same page. Next, a termination clause establishes notice requirements. This means it outlines how much advance notice must be given before terminating the contract. This allows the other party to prepare or address any issues that may have arisen. Additionally, some termination clauses include a right to cure. This gives the breaching party a chance to fix any problems before the contract is terminated. This can help prevent premature endings and maintain business relationships. The clause also outlines the consequences of termination. It clarifies what happens after the contract ends, such as the return of assets or payment of fees. It may also include ongoing obligations like confidentiality or non-compete terms. From a risk management perspective, a well-drafted termination clause limits liability and protects business interests. This is especially important in complex agreements where stakes are high. By detailing termination rights and obligations, you can avoid costly litigation down the road. In practical terms, including a termination clause helps businesses manage contractual relationships more effectively. It allows for flexibility to exit agreements when necessary while ensuring legal compliance. Drafting these clauses carefully is essential to ensure they are enforceable and aligned with applicable laws. A termination clause is not just a formality. It is a fundamental part of contract drafting that helps prevent common legal mistakes. It promotes transparency, reduces conflict, and safeguards the interests of all parties involved.